Good morning, everyone. In political science and U.S. government, I thought I'd put up I'm trying to keep them a little bit shorter, so I'm breaking it up into two videos. And this is about civil liberties and civil rights and the Bill of Rights that were added to our U.S. Constitution 2 years after the adoption of the framework of our government. It surprised a lot of people that the initial Constitution didn't have a Bill of Rights. And most people that take this class, I think they're really excited and most interested in fundamental rights and liberties that we retain as people, what the government can't interfere with, and what the government must help protect and preserve. Is sort of the heart and soul of many of us, or many of our views in terms of what the Constitution means and why it's important to us. And so I thought I'd break it down to two parts. One, just talking about the framework of what the history was with adopting the Bill of Rights and later amendments to the Constitution and how they're supposed to be applied and whether they were supposed to be applied to state entities and local entities or just the federal government. And then I'll do a second video just on what I consider to be the core civil liberties contained in the Bill of Rights. Some of them are a little bit arcane. They don't come up like we're not going to spend any time on the third Bill of Rights by any means. It's quartering of soldiers in your home. But let's get into it. So we know the framers went down in 1787 to create a new constitution, or at least amend the current thing we had called the Articles of Confederation. It was around for less than a decade, but it was falling apart. It wasn't working. So they went down. We know they left. And they left prior to adding a Bill of Rights, which would be protections against the government's overreach, that certain basic fundamental civil liberties must be recognized. And that's what the Bill of Rights are about, civil liberties. And there is usually a great test question. A lot of people like to talk about it. Your book even makes a pretty strong distinction on this. What's the difference between a civil right and a civil liberty? I guess it is pretty important to know, but I think for the most part, most of us walk around using those terms interchangeably. I guess there's a danger in that. You should know the distinction, but I only ask one test question usually on it, and it's pretty straightforward. But you should be able to identify the differences. But the reality is, if I had a bunch of attorneys in here who aren't practicing constitutional law or civil rights law, they may be befuddled by trying to come up with a definition distinguishing between a civil right and a civil liberty. In a nutshell, a civil liberty is the recognition of those inalienable rights, those things that are so precious to us as human beings that our forefathers recognized them as being sacrosanct, meaning the government shouldn't be, it's beyond the government's reach unless they have, this is the thing they didn't say, but unless they have an extremely compelling reason to do so for basically the safety of others within society. Only in the rarest circumstances can government reach, impact, interfere with our civil liberties. Things like freedom of speech, freedom of religion, those freedom from unwarranted search and seizures by our government. Those are civil liberties. The government can't go there unless it's got an extremely compelling rationale for doing so, and it's their burden to prove why. Very rare, actually. So what's a civil right? A civil right is the government actually taking steps to ensure that all people have the same fundamental access and application of the laws equally. We want everyone to be the same under the law, and therefore a right is an acknowledgement that the government will take overt steps to ensure equal access and equal application. And I'm not saying it works perfectly, and I'm not saying it's stupendously, our history isn't perfect on that at all, but it is an aspirational goal. A right is, hey, I have that right, just like my sister does, my brother does, my neighbor does. We all should be treated equally under the law. That's what it means to be a right. The government's going to take overt actions to ensure equality in our access to employment in certain circumstances, our treatment under the law, whether we're of a certain ethnic, religion, or other non-mutable characteristic. We're all going to be treated equally under law, and the government's going to take overt actions to make sure that occurs. That's that distinction. The next, I think, that troubles a lot of people is the Bill of Rights didn't come with our Constitution initially. I got to admit, that kind of shocks me. And there's a film I'm probably going to put up, not by me, obviously, from YouTube that I thought was fantastic about the construction of our Constitution. And there's a lot of people that theorize that the framers were down there for weeks in the hot Philadelphia summer. They really struggled to put together a Constitution to set up our framework of government. And they thought it was a narrow application of power to a centralized government. And therefore, the need to create a Bill of Rights wasn't so paramount to many of their views. They just said, we don't need it. The federal government's going to have narrow authority. They're very unlikely to have the ability to interfere with everyday individual civil liberties. We don't really need to embody that in the Constitution at this time. We're just too tired. I don't buy the just too tired argument, but I buy the other aspect of the argument that they saw the role of the federal government to be somewhat narrow, regulating interstate commerce, the ability to tax, to raise armies and navies in the military, the coinage of money. How would that kind of role really be impacting our civil rights and civil liberties? It didn't seem like the greatest of concern. But after they left, those arguments came up fairly vehemently in many of the communities by the Anti-Federalists. In fact, the main thrust of the Anti-Federalists was there wasn't any protection for civil rights within the document, other than the handful, which I'll go over in a second. And so when they were passing the proposed Constitution from state to state, the qualms got big over the lack of a Bill of Rights within a document. Almost every state in their state constitution had a fairly comprehensive set of rights articulated in their constitutions, and they said, we're not going to adopt this. So what happened? The Federalists basically said, we promise we will add in the First Continental Congress, when this Constitution is adopted, first order of business will be to add a Bill of Rights that we all can agree with, and we'll send it around to the states for adoption. I was surprised that people would buy that argument. It's kind of like me buying a car from you and saying, hey, after the deal is completely done, we've adopted it, you own the car, I've got the money, I promise later I'll put 4 new tires on for you, a couple months down the road. Obviously, there's no binding authority to make that happen. So those promises were about integrity. And I got to give them credit. They did follow through, and they did add the Bill of Rights 2 years later. So we have a constitution that's unique in the sense that I think too, that one of the critical aspects of it is protecting our persons from government overreach. That's kind of an essential aspect of it. And yet we walked away from the table in 1787 saying, we'll do it later once the Constitution's adopted. Within a couple of years we did, and in 1791, because it took 2 years to get the Constitution basically adopted, then it took another 2 years to put in the Bill of Rights. We lived without a section of Bill of Rights. And most people, a lot of people, including James Madison, who authored most of the Bill of Rights, didn't think it was that necessary, because the federal government would be meddling in areas that would impact our civil liberties and our civil rights, or that we see as civil rights today. So the Bill of Rights, it's not the only area where we find critical civil liberties identified. And 2 of the main ones that I wanted to talk about briefly, it's in Article 1, Section, I believe both are in Section 9. I don't have these always memorized, although I should. And one is called the Bill of Attainder, and the other one's Habeas Corpus. They're not in the Bill of Rights. Those are found literally in the body of the Constitution, Article 1. I think both are in Section 9. And what a Bill of Attainder is our framers were upset. The Bill of Attainder is Article 1, Section 9, Paragraph 3. A Bill of Attainder is banned. We can't have any of those in the United States. Thank goodness. Hopefully no other countries still have those kinds of things. But if a Bill of Attainder is literally the legislature passing a law saying Jim Corman is guilty of treason, he's to be punished by 10 years of incarceration, or he's to be executed without a trial. It's a declaration by the legislature that somebody's existence, by who they are or their identity or their affiliation, makes them guilty of some crime that they identify through legislative action. Most people don't even worry about this anymore, but we got to remember, during the colonial era, the British government was basically doing things like that to some of the colonial agitators, and we thought that is really repugnant, denying us basically what we consider to be due process and fundamental fairness. So we put that in the body of the Constitution. No bills of attainder. It comes up occasionally where the legislature will try to pass something that is basically going after one group of people and not another. and basically identifying them as being criminal by their very existence. Very rare, but it's good to have in the Constitution. The reason why it's rare is hopefully lawmakers know that you can't do that. The next is habeas corpus, and it's still used to this day. I use it regularly in my law practice. It's also in Article 1, Section 9, and this relates to the ability of someone being held by the government to petition. You literally fill out a habeas corpus form. It's a one-page document in most jurisdictions. And you basically say, hey, I'm being held right now at the Worcester House of Correction or at the Shirley State Prison or at the federal penitentiary at Danbury, Connecticut, and I demand to be brought before the appropriate court for the government to show justification why I'm being held. And this really makes the government have to have integrity on why they're holding people in detention. Oh, we had a trial, Jim. You were convicted of armed robbery. You got a 7 to 10 year sentence last year after a jury convicted you. You had due process. You had an attorney. You put up in a defense. The jury felt you were guilty, and you appealed that, and the appeal was denied. That's why you're being held for the next 7 to 10 years at the Danbury Federal Penitentiary. Oh, okay. And most people say, well, this isn't going to come up that much. It actually comes up quite a bit because sometimes there's confusion in why people are held. Is there a bail currently on a case? Should they be released? Is the term of their sentence completed? And occasionally there are, I hate to say it, but basically in our society, there's a bureaucratic mess sometimes, and someone has completed a sentence, but there are multiple counts involved, and some were to run concurrent, meaning at the same time, some were to run consecutive on and after, and there's confusion about whether someone should still be held or not. But the power of habeas corpus is to legitimize in the eyes of the public, because these are all public forum type things, why someone's held. And this is not in the Bill of Rights. This is in the body of the Constitution itself. So we have some language already trying to reach out to make sure there's integrity in our government when it interferes in individual freedoms and liberties. So I wanted to bring that up. The next thing I wanted to bring up before I get into the second video, which will be about the actual Bill of Rights, will be who they are applicable to. This surprises a lot of people. And you can see it right in the First Amendment. Congress shall pass no law. What does it mean, Congress shall pass no law? It was a direct recognition. The Bill of Rights was a limitation on federal government behavior only. It did not, for the longest period of time, almost a century really, impact state government behavior. So if the state government was curtailing your freedom of religion, if the state government was curtailing your freedom of speech, if the state government was searching you unreasonably in terms of what a society expects levels of reasonable privacy, if the state was giving you a cruel or unusual punishment or setting very high bail, that's the Eighth Amendment, you couldn't object by raising the federal Bill of Rights. That's Madison's whole argument. The federal government's not going to get involved in these things too much. You have to look to your state constitution and your state civil liberties and civil rights to order to seek protection in those areas if they exist at all. This shocks a lot of students. What do you mean the Bill of Rights? Of course I have freedom of speech. No. It took many, many years before the federal constitution, the Bill of Rights, became applicable to state or local action as well as federal action. Shocks many people. In fact, and this is part of federalism, the last chapter we talked about. Most of you seem to think it's a good system, it works well, but it is very confusing sometimes. And to this day, I do a lot of criminal work, and the federal government's Fourth Amendment, a lot of people are, I think, CJ majors in the class, are going to have to deal with search and seizure and how far you can go, and do you need a warrant? Don't you need a warrant? What's reasonable under the circumstances? Everyone talks about the Fourth Amendment. Well, when I'm in court, I talk mostly about the Massachusetts article, the Declaration of Freedoms, Article 14. Don't get it confused with the 14th Amendment, completely irrelevant. I should say irrelevant, unrelated. But the Massachusetts Constitution, Article 14, gives us greater privacy and individual rights vis-a-vis a government search, police search usually, than the federal Constitution does. And so I find it more valuable to argue Article 14 than the Fourth Amendment. I always argue both. The language, if you look them up, I urge you to do this, kind of fun. If you looked up Article 14 of the Massachusetts Declaration of Rights and compared it with the Bill of Rights number 4, Fourth Amendment, Nearly identical language. These guys, when they went down and decided to create a Bill of Rights saying, well, we're going to start from scratch, we'll have to think these things up, they lifted a lot of the stuff right out of the Massachusetts Constitution. Now, if the language is the same, why aren't the interpretations the same? Because under the federal Constitution, the state courts of Massachusetts may have a very different interpretation of what that document should mean, creating a dichotomy. And that's what my master's degree was written on. My master's thesis was the dichotomy between the same rights under the federal Constitution and the state of Massachusetts Constitution. It creates a distinct and disparate system of justice. And maybe that's what we want. I like Massachusetts being, well, I'm a criminal defense attorney, so I like the fact that it's a little bit more, I think, progressive in protecting individual civil liberties and freedoms as opposed to the federal government. So what do you want to get out of this lesson besides me babbling on and on and on? The federal Bill of Rights in our United States Constitution was not applicable to the states until really the 20th and 21st centuries, 1900s, 2000 and beyond. Why? Because the framers didn't mean it to be. It was only to federal government. And when did it change? Well, in my opinion, the most important amendment to the United States Constitution, and this is not in the Bill of Rights, it's added later, I think it's 1868. It is the 14th Amendment to the United States Constitution. The 14th Amendment to the United States Constitution says, no state shall deprive its citizens of due process of law and equal protection of the law. Sounds simple, and sounds good, sounds great. I think we all agree that's a good thing. But what does it actually mean? Over time, the Supreme Court has told us that means that certain fundamental civil liberties and civil rights cannot be ignored or violated by state action and local action as well as federal action. It basically made what? It basically threw the concept of what we call incorporation. This is a test question. If you're not listening to me and you're doing things other in the background, pay attention for this second. Over time, the courts, especially the Supreme Court of the United States, has made the Bill of Rights applicable to state and local action through the doctrine of incorporation by arguing that the 14th Amendment's mandate that no state can deprive its citizens of due process of law and equal protection of the law. Therefore, the Bill of Rights are applicable to them. They didn't take it in one big swath. It was case by case. First Amendment, then the Second Amendment wasn't until past 30 years has the Second Amendment be applicable to the states. They were arguing recently in Michigan that the Second Amendment wasn't applicable to a state law curbing the ownership and possession of certain guns. They said it only applied to the federal curtailment of that. They lost. Now the Second Amendment's incorporated. And pretty much now all of the Bill of Rights, all of the core Bill of Rights, what I think are essential to civil liberties and civil rights, are now applicable to the states through the doctrine of what? Incorporation via the 14th Amendment. Okay, so that's still hopefully surprising some of you. Maybe you all know this already. I don't know why you're in class if you already know this already. I didn't know this for the longest time until I was studying it, that the Bill of Rights were not applicable to state action, meaning local action only applied to federal government. And those of you that are CJ majors, the federal government doesn't really take that big a role in criminal justice. Yeah, they take on really big cases that are applicable to 2 or more states or that have applicability under a specific federal statute. But in the big picture thing, something like 96% of all criminal matters will be state jurisdiction. So for the longest period of time, defense attorneys and prosecutors couldn't bring up the Bill of Rights in the United States Constitution because they weren't deemed applicable to state action. They are now. Why does it matter? It's important to know the history of our nation and how it's been applicable and how it's evolved over time. So we leave with the Constitution. The Bill of Rights are added 2 years after the adoption of our federal government's framework. And sometimes, I was thinking about my father the other day, and he used to always ask me, what'd you learn today in law school or in college? All through, I kept going to college my whole life. Once I started to like it, I hated it first. And as many of you know, I dropped out and I didn't feel like I was college material. And the good news is it changes over time, hopefully, and you stick to it too. But I can remember my father always asking, what'd you learn today in college? And maybe people at your house do the same thing. Your loved one says, hey, what'd you learn today at school? And usually say, nothing. And I always remember my father, who was quite a humorist, would always say, that's fantastic. I'm glad our money's being well spent, because I used to get a lot of government loans and aid. We were a rich family, because I'm glad our tax dollars are going for your education. But one thing I do want you to learn from today is this concept that the Constitution really has two fundamental purposes. The first part, which you already studied, was creating the framework of government, how government shall operate, the checks and balances, the different rules between the three branches, although the judiciary wasn't really talked about too much in the Constitution. That develops later. The other, and that's the part we're going over now, is to limit the government's reach into our private affairs. That's the second purpose of the Constitution, limiting government authority to protect our personal liberties, our civil liberties. That's the second. So, it's really overly truncated, this definition of what the Constitution means, but you should know Constitution stands for two basic principles. One is framework of government, and the other is putting a limitation on the government so we are protected in our civil liberties. So you can't say you didn't learn anything today if you didn't know that already. So now the Bill of Rights are now applicable to the states, and we know the amendment process. I might as well put it in here. It's going to be on your test. If I didn't already put it on the test, it's going to be on the final. It has to be. How do you amend the Constitution? Technically, the Bill of Rights are an amendment. They had to go through the amendment process to make those 10 amendments adopted. There's two different processes. They're both kind of similar, and they're certainly similar in terms of the actual approval process in the end, and it's not easy. We've only amended the United States Constitution 27 times, and if you take out the first 10, because that was a package, 17 times. The framers recognized that we needed a safety valve to make changes when the nation really felt they needed a change. But they also didn't want it to be done in the heat of passion and willy-nilly. They wanted to be over very important, significant changes that were viewed essentially by a vast majority of the nation in order to make it happen. And I agree with it. I think that's a good thing. But we haven't really tweaked it too much. Donald Trump not too long ago said he was negotiating potentially doing a third term. I think he has to win the second one first, but I don't know why he said that. But I watched the video and he did say that. I think he was doing it a bit tongue in cheek because we know we have a constitutional amendment that came out in the 1950s that said presidents can only sit for 2 elected 4-year terms. They could technically serve a period of another term if a president should resign or die in office. So like Teddy Roosevelt, for example, he served the remainder of McKinley's term, ran on his own term and won, but he could have, and he did run, but he didn't win. He could have run for another full term, but you only can get 2 elected terms. You can only do 8 years elected directly into the United States, or not indirectly through the Electoral College. So we don't tweak the Constitution very much, but when we do, what do we have to do? There's 2 different methods. One is if you can get 2/3 of our country, I believe it's 38 states it comes out to basically vote on the need to change the Constitution, then the proposal will go throughout the rest of the United States. So 2/3, basically they have a constitutional conventions in all the states. 2/3 of the states recommend making the change. Now 3/4 of the states have to agree. The second part of the 2-prong approach, the second prong is always the same. 3/4 of our states have to agree on amending the Constitution. It's the first prong that's a little different. So one of the first prongs is the states have these constitutional conventions. 2/3 of the states make the recommendation. The other is also a 2/3 rule. 2/3 of the House of Representatives and 2/3 of the United States Senate agree, and they also have to agree, on what the constitutional amendment should be to the Constitution. And then it's brought out to the states again, and the states 3/4 have to pass it. And some things that seem very, very popular that I think some people think will pass tend to fail. It's got to have a real sense of urgency and a sense of need, and it has to be depoliticized. It's pretty rare to get these passed. One of the more significant ones, not my time, but not really my dad's time. I fall in between the 2 generations. But in the Vietnam War, many of the people serving in the Vietnam War were between the ages of 18 and 21. And there was a sort of disgust that these young people were going over serving and dying, but they weren't old enough to vote, because back then most states had the requirement, and the federal government had the requirement, that to vote in federal elections, you had to be 21 years of age. That amendment in 1975, I should know, but I don't. That amendment was one that was fairly universally popular because of the nature of what was happening. People that were losing their lives couldn't really participate in our democracy in the same way as those people that were staying at home and making those decisions. And that amended the Constitution. Basically now it's 18 as a threshold. Now, Here's the thing that's going to throw people off. And I already went way too long, and I thought there was going to be a little introduction before I got into the Bill of Rights. The Bill of Rights, again, is applicable only to government action. What do I mean by that? What if I had a private party here tonight, my friends are over, and somebody's talking about, I don't know, something I don't want to hear about. Talking about how we have to save all the baby giraffes in the zoos and get them freed and sent back to the African continent. And I don't know, I want to talk about sports. So I say, hey, you're out of the party. I'm throwing them out. And that person says, but you're violating my free speech rights. And I'll say, yes, I am. But it doesn't matter because I'm not the government. Who's right? I am. When we raise these issues about rights and civil liberties, it only pertains to government action. So if it's a private entity interfering with my free speech, arguing my religion, my personal effects. So if I'm in a private company and the private company says, in order for you to come in here, I got to search your bag to make sure you don't have cameras because I don't want you taking pictures of any of the schematics we have. Am I violating your Fourth Amendment right to be free from unreasonable search and seizures? Maybe, maybe not. But the point is, it doesn't matter because I'm not an extension of the government. And that's the test. It's got to be the government behaving in this conduct, or it's got to be on the veil of government. So if I'm doing it in my business, but I'm really going to call the cops immediately after because I found some drugs on you or some other illegality, now I really become an extension of government, and therefore it would be banned. But I want you to remember, it's about government behavior under the different sections of the statute in order to be applicable. So when my kid gripes and moans when I tell him to be quiet about something that I'm sick of hearing about, and he says, and they have said, it goes, you're violating my free speech right. Goes, I'm not the government. You have no redress. You can't go to court and say, my father told me to be quiet. It's going to be the government. Now I'm going to segue into a different video. This is a little long, but I want you to get your thought process going about the nature and the scope of civil liberties and civil rights.